All right. So thanks everybody for joining us for this, what will be, I'm sure, a very fun session of young legal scholars papers that were competitively selected for this session. You probably see that Richard Epstein is not sitting up here. Unfortunately, he had a family medical problem that just needed to be attended to. And so, of course, we've replaced him with 4 different people. This will not surprise anybody who knows Richard. Without further ado, let me turn it over to Dean McAllister, who will take matters from here.
Thank you, Lee. Although you stole my joke, I was going to say, it takes 4 people to be Richard Epstein. But I'm very grateful for the 4 people who volunteered, because otherwise it was going to be on me. And I'm a dean by day, and I don't get to spend nearly as much time with scholarship as I would like. So I'm really honored to be here and have a chance to spend time with some really wonderful papers. It's my job as the dean, of course, to be like the gatekeeper, moderator, police traffic cop here, so that's a fitting role. We're going to do this in 2 different panels, and we have our 4 presenters. I'm going to keep time. Our presenters are going to have about 10 minutes, followed by about 8 minutes of comments, and then a brief response from the paper presenter, and then opening it up for group Q&A. And I'm going to introduce everybody sort of at first on our first panel, and then hand it off to Professor Dickinson, who's the first presenter. So without further ado, on the first panel, our 2 paper presenters. First, Greg Dickinson, who is an assistant professor of law at the University of Nebraska College of Law, which he joined after starting his tenure track career at St. Thomas in Florida. So he got some better weather, I guess, in Nebraska. Professor Dickinson has been a fellow at Stanford's Law, Science, and Technology program since 2019. He has an undergraduate degree in computer science and earned his JD from Harvard. He practiced law for a decade before entering academia. He'll be presenting law proofing in the future. Commenting on Professor Dickinson's paper is Professor Adam McLeod, who is the Katherine A. Ryan Chair for Global and International Law at St. Mary's University School of Law. Professor McLeod is also a senior research fellow on the Center for Religion, Culture, and Democracy, and lectures the James Madison Program Summer Seminar on the Moral Foundation of Law at Princeton. Our second paper presenter is Charlie Capps, who is an associate professor of law at Sandra Day O'Connor College of Law at Arizona State University. Professor Capps earned his JD and his PhD in philosophy from the University of Chicago, and he completed his undergraduate degree in economics at Stanford. Before arriving at Arizona State, he was an associate scholar at Chicago, and before that, a deputy solicitor general for the state of Missouri. Professor Capps will be presenting what interpretation just is and why it matters. Commenting on Professor Capps' project is Kevin Walsh, who is the Knights of Columbus Professor of Law in the Catholic tradition at Catholic University Columbus School of Law. He teaches and writes on federal courts, constitutional law, and torts, among other subjects, and previously was on the faculty at the University of Richmond School of Law. Professor Walsh clerked for Justice Scalia and Judge Niemeyer in the Fourth Circuit. So we're really grateful to our commenters for stepping in at the somewhat last minute. So thank you so much, and I'm going to hand it off to Professor Dickinson to get us started.
All right, well, thank you very much for that introduction, very kind of you. I couldn't help but notice my position on the schedule, where the last session of the day, which could lead to some inferences, and the inference that I prefer that to lead to is that I am the milk at the back of the grocery store, and everyone has to go through other things to get to me that may be sound or not. My topic is for today, law proofing the future. And that may sound backwards to you. And in fact, I almost hope it does. There have been a number of presentations or programs in various academic settings recently that talk about future-proofing this or future-proofing that. The very seed of this paper began when I heard the term future-proofing the law, and it struck me as so very backwards. And the reason it did, and I hope it will you after I tell you why. Imagine some of you, like me, may have been, or certainly are old enough to remember, may have even been doing some computer programming in the 90s or 2000s and encountered the programming language COBOL. Imagine hearing the term future-proofing COBOL, or to borrow from Elon's language this morning of Newtonian physics, future-proofing Newtonian physics. All of that sounds backwards, and I think the reason it does is because law, like language, computer or otherwise, or like human study, it's for our benefit. We aren't protecting it because it must be protected. It is necessarily subject to change because it's for human benefit and not the other way around. And so now I declare, it should strike you as strange to be protecting the law. The law's for us. We'll do whatever we want with the law so long as it is for human benefit. And that will, in a way, be the central claim and is the central claim of the paper. There are, I guess, two steps, or a couple of steps built in to the idea behind the paper. One is how very natural it is, notwithstanding the fact that I think law should be very constant, really quite constant. It's very natural to have an impulse to change the law, or an impulse to add on top of the law. Just a few examples. I want to start with a few examples of that impulse and then discuss a bit about why I think that is so very often a bad idea. And so first, the examples. This was a really fun project, I should say that, and you'll see why. Hopefully you'll think it's fun too. But in the course of this study, I learned a new sin, and that is with the technology of the invention of the printing press, you got shortly thereafter the new sin of bibliolatry, which I hadn't heard before, and the idea was improper reverence for book to the subjection, I suppose, of God. You are reverencing the book more than you should, and that became a problem with the printing press. And I don't say that. It's not as if that was a joke. That was a very real concern. And similarly, there have been other concerns about media. Twitter and social media and the like are not the first. You also had comic books. There was a huge comic book scare in the 1950s, Senate hearings and everything, nearly legislation, because of the dangers that comic books posed to youth. Also, I want to actually read you this. I couldn't believe it when I found it. But novels in the 18th century and thereafter, there was concern that they would lead to idleness, especially among women who might dream of greater social status if they immersed themselves in too many simple novels. I just can't resist sharing it with you. This is from a book called The Evils of Adultery and Prostitution, 1792, a social thinker commenting on the evils of society. A cause of profligacy in the present age is that mass of novels and romances, which people of all ranks and ages do so greedily devour. Such as devote their time to this species of reading are seldom capable of attending to books where solid instruction is conveyed. They never can be expected to relish that reading which requires any degree of attention or stretch of thought. Novels dress out vice in pleasing colors, gild over all of its deformities, and thus insensibly instill the deadly poison into the thoughtless and unwary of heart. Many young girls from morning to night hang over this pestiferous reading to the neglect of industry, health, proper exercise, and to the ruin of both body and soul. Very earnest, very sincere, and it should sound a little bit like social media and app discussions today. And I say it not so much to make fun of it. I don't think that these people are silly for having had such worries, but by looking at the past, I want to put a check, a scare on the sorts of discussions we have now, because just as then, our discussions feel so very new and fresh and scary, unlike anything before. Another example I ran across in the course of writing this paper is elevators. Imagine how scary an elevator would be. It's moving you around. You don't really see how. You don't really understand much of what's behind it. And terrifying. so terrifying that the first first department store to use one eventually abandoned it because no one was brave enough to use it. And what eventually pressed them into service wider is P.T. Barnum of circus fame put on demonstrations where he would cut a rope and the elevator would fall and an emergency brake proved the safety of the elevators, and that eventually saved the day. And the reason I share these stories is because I think there's a parallel with regulation today across all sorts of technology, and I think it's extraordinarily dangerous. We can see with wisdom of hindsight that regulating the novel or over-regulating, at least the elevator, is, well, charitably wrong-headed, I guess. But we can't yet see what we will be regulating in the future or are regulating now that future generations will think was wrong-headed. And so I think there's some wisdom to be learned there. And the way that I'll talk through this, we don't have a whole lot of time, but the way I want to talk through it is to look at some of the particular regulations and what might be their flaws in retrospect. And so I'll take up elevators first as a more technological example than novels. Some of the regulations, for instance, rope strength was specifically specified, operator age, how old you would be, speed limits. There were speed limits of up to a couple miles per hour on these things are so fast now, but a couple miles per hour was the speed limit. There were bans on women operating elevators who were thought not capable. There were requirements that if women operated them at certain periods of time in certain locations that they be given seats because the women surely were not capable of the manly feat of pulling a lever. It truly actually wasn't hard. But this was the idea. But now think about a standard torts class. All of this could really be handled, and in fact was, before these regulations came to be, by ordinary reasonable standard of care type principles. The way that I see these regulations as evidence of failures are, well, if you dig a little deeper into the historical record, you can see that much of what produced these rules was not even. You are already thinking it's bad because they're misguided and wrong, but they weren't even a fair attempt at getting it right. Instead, they were, for instance, examples of elevator legislation having been captured by unions who were excited now that everyone that operated an elevator would have to be unionized, for instance. Also, to the detriment of women, there were protests at the time by women that they were being excluded not for their safety, but in order to give the unions of male elevator operators greater power. And so not only do you have wrong-headed rules, but often captured rules that couldn't be right even if you tried, and yet are also subject to lots of the flaws of the democratic process. Unfortunately, I don't have time to share any more than that preview with you. I hope you'll read the paper. I hope you'll get as excited about it as me, but I'll leave it there.
Well, I enjoyed reading this paper. Greg, I think, correctly has expressed his confidence in the paper, in the parts of the paper that he didn't have time to discuss, in the efficacy of common law norms and institutions to solve novel problems, just as they have throughout our history. And as a result, he calls us to lay down our arms, to welcome our virtual overlord, the future. The future is not a threat. The future is a very vulnerable blessing. The real threat is, in fact, what he calls the law. And so he advises us to default to damnum absque injuria, and where it's necessary to hold actors responsible for new technologies, the use and development and deployment of them, common law solutions should be our preference as opposed to specific regulations. I want to make three suggestions for the paper to help make it a little more persuasive, perhaps, to those who think that the future is, in fact, something to be guarded against. First, I want to suggest that some people might find his examples too carefully curated. So Yes, pearl clutching over novels, or clutching mitres and crowns over the printing press in retrospect looks rather silly. On the other hand, you can identify examples, some from old history, some from very recent history, where perhaps we didn't adequately fear the dangers of new technological innovations enough. Immediately calls to mind Jonathan Haidt's book, The Anxious Generation, some of the understudied deleterious effects of smartphone technology placed in the hands of children. What could go wrong? Artificial intelligence bots encouraging teenagers to commit suicide. These are real risks, and these are to be guarded against, certainly in rational and careful ways, but to be guarded against nonetheless. The bottom line is that 21st century technologies are both similar in some respects and dissimilar in other respects to technological innovations of earlier centuries, to which we have addressed using common law norms and institutions. So it's then important to parse through the similarities and differences to know the extent to which established legal doctrines and institutions can redress new injuries. We certainly want to avoid the law of the horse problem, but this still leaves open the question which common law norms and institutions ought to apply and how in particular cases. I'll give one example of this problem in current debates about digital privacy and personal information and digital records, a debate that's currently waging back and forth between Chris Newman of George Mason and Danielle Donfro on the application of bailment, the concept of bailment to protect digital records. Chris and Danielle have very different ideas of what a bailment is. Chris thinks it's exclusive physical possession in essence. Danielle thinks that it's essentially a trust. And which of those views of bailment you adopt gives you a very, very different application to intangible resources like digital records. For Chris's concept, bailment does almost no work with respect to intangible assets. For Danielle's, it does quite a lot. And so we need further specification of these common law norms and institutions. I have great confidence that the bailment can solve a lot of these problems, but there are questions to be addressed. Second, I want to suggest a few distinctions, conceptual distinctions that might help tighten the argument, and these are common law distinctions. The first is between what a common law jurist would call a declaratory enactment and what they would call a remedial enactment. Declaratory enactments, of course, restate and sometimes clarify pre-existing common law norms and institutions and apply them to new contexts, whereas remedial statutes are understood to change some proposition of the law. So, for example, we can declare the law of agency as applied to artificial intelligence machines, or perhaps bailment as applied to digital records, versus a moratorium on the development of AI coupled with criminal sanctions. I would be in favor of the former. I would hesitate as to the latter. A second distinction would be between public sanction or sanction for public wrongdoing versus private remedies. Criminal laws have to be generally applicable in perspective only, whereas private law remedies can be much more pluralistic. And so I suggest that the reference to the law with which the paper opens might need a little more differentiation here. Finally, I would mention the role of trial by jury versus the role of the judge. And actually, I think this is more important than the distinction between judiciary and legislature. The jury is a vehicle for importing the community's mores and rights into judgments. Juries need not all agree on questions, and so we have an institution of plural judgment which allows for experimentation. It is, in fact, the quintessential common law institution for resolving new questions. So all of this leads me to believe that there may be some reasons in favor of legislating, carefully, but legislating nonetheless. Legislation could help us resolve some of these ambiguities about the meaning of property, such as the bailment question I just raised. Also, contract. Whether we conceive of contract as promise, as Charles Freed does, or manifestation of assent, as the Second Restatement does, could determine how we respond to failures of what Greg identifies as dark patterns in the choice architecture in digital platforms. Similarly, we might find that there's justifications for remedial statutes in particular contexts. The ambiguity around what constitutes a license would be relevant under the Computer Fraud and Abuse Act, and we might need to amend some of these statutes in order to bring them more in line with the common law. All of this suggests a limited but important role for declaratory legislation to explain how we can apply these established norms and institutions to these new problems. And then occasionally we might find, as we go along, needs for new remedies or practical applications.
Fantastic. Professor Dickinson, would you like to take a moment to respond?
Sure. Just a few things I would say by this prodding, which I appreciate. The curated examples, I think in a sense that's exactly right, because I wanted to find memorable examples that would stick with you and say, well, I don't want to have done that come the future. So I would turn, though, to emphasize what the other thing I think you could see is. So one set would be legislation that in the future we will think was silly. The other would be legislation that in the future we will think was on point. And yet I would say even for that set of on-point legislation, we would be better handling it through evolution of the common law in some of the ways that you suggested in your other comments, rather than prospective legislation that tries to get it right, notwithstanding the fact that we know very little yet about technologies that are still under development. And so there's a separation between what will be the defect in the future legislation and what the solution would be. Another point that I want to agree with you very much on is the idea of bailment and how we conceptualize it having a very significant effect on how that analogy then gets applied under the modern law. This is almost an example of what I described a moment ago happening. If we get new technology, it's going to press on those common law distinctions in ways that will be, I suppose, alarming to the particular judge that it ends up being stuck figuring it out. But through the process of kind of evolutionary common law decision-making, I expect that courts would eventually reach a reasonable conclusion in most instances and be hopefully less prone to legislative capture or the creation of kind of incoherent silos where a piece of legislation lops off something that's not really dissimilar from other human conduct, but is because it has a special statute applied to it. And so really just a point of agreement and elaboration about how I see that playing out, and I very much appreciate the comments.
Thank you both very much. Professor Capps.
According to Cass Sunstein, there's nothing that interpretation just is. The concept of interpretation is capacious. It encompasses a broad variety of methods for extracting meaning from a legal text, such as the Constitution. And each of these methods is entitled to be treated as a kind of constitutional interpretation, a form of constitutional interpretation. And judges are free to select from among them on normative grounds. Francisco Urbina actually goes one step further. So he agrees with Sunstein that there's nothing that interpretation just is, but he adds that even if there were, it wouldn't matter. So what I argue in my paper is that Sunstein and Urbina are both mistaken. There is something that interpretation just is, and it does matter. So what is interpretation? Well, I argue that to interpret a text just is to form a judgment about what the author of the text intended to communicate. This is what interpretation is in virtually all non-legal contexts. So to give you a few examples, think of interpreting a shopping list or interpreting a restaurant menu, interpreting a map, interpreting a road sign, interpreting your boss's directions. In all these contexts and in many more, to interpret something just is to form a judgment about its intended meaning. What did the author of the shopping list, what did your boss intend to communicate to you? There are a couple of examples or contexts that might be a bit more controversial. So some people think that literary interpretation is different. I think they're wrong. Happy to explain why during the Q&A. I give an argument in the paper. There are also some metaphorical uses of the term. So sometimes we'll talk about interpreting someone's actions, for example, or interpreting data. We talk about scientists interpreting data. And there, I think the reason why the term interpretation is appropriate is because it's as if the universe is communicating something to the scientists through the results of their experiments. And what scientists are up to when they're interpreting their observations is they're trying to decipher what that is. What is it that the universe, as it were, is trying to communicate to us about its workings through the results of our experiments? So in virtually all non-legal contexts, interpretation just is judgment about intended meaning. And legal interpretation is no exception, or so I argue. If we want to know what legal interpretation is, then we need to pay attention to what the paradigmatic practitioners of legal interpretation, judges, purport to be doing when they're supposed to be engaged in the interpretation of a legal text like a statute or the Constitution. It turns out what judges purport to be doing when they're supposed to be engaged in constitutional or statutory interpretation is identifying the intended meaning of the text. I think this is especially clear in the context of statutory interpretation. Over and over again, case after case, judges repeat, it's almost like a mantra, they repeat, the goal of statutory interpretation is to ascertain the intended meaning of the legislature. They say that, or slight variations on that formula all the time. I mean, you can find hundreds of cases if you just do a quick search on Westlaw. And in the constitutional context, judges aren't always quite this explicit. Perhaps that's because, unfortunately, constitutional interpretation has become quite politicized. But even if not explicitly, implicitly, over and over again, and this holds true across differences in ideology, across time, judges will, at least implicitly, adopt as a criterion of what makes a proposed constitutional interpretation, proposed interpretation of a constitutional provision correct, whether that interpretation captures the intended meaning of the provision. So in the legal context, too, I submit interpretation just is judgment about intended meaning. Now, why does it matter? Well, I argue that it matters for at least 4 reasons. I'll try to explain them quickly. First, interpretive choice. Many scholars, for example, Richard Fallon, Adrian Vermeulen, Cass Sunstein, Francisco Urbina, and several others, many scholars argue that judges should choose a method of constitutional or statutory interpretation on the basis of its normative credentials, how normative appealing it is. So there should be a choice of interpretive method on normative grounds. Well, if interpretation just is judgment about intended meaning, then interpretive choice is impossible. You can't do it. There's no such thing. Why? Well, judgment is essentially aimed at the truth. You don't count as forming a judgment on a given matter unless you're aiming at the truth of the matter. So if you adopt a method of arriving at an answer to a question, not on the ground that the method is going to lead to an answer that's true, but on the ground that the method is going to lead to an answer that's desirable, you don't actually count as forming a judgment on the matter at all. You're like, this is the analogy I offer in the paper, you're like a person who's given a math worksheet with a bunch of addition problems, who just writes 7 as the answer to every problem on the theory that this is going to bring good luck. All right, whatever this person is up to, it's not addition. And so in the same way, if interpretation just is judgment about intended meaning, you can't actually adopt a method of interpretation on normative grounds. By virtue of adopting the method on normative grounds, you don't count as adopting it as a method of interpretation. So that's the first implication. There's no such thing as interpretive choice. Second, once we see clearly that interpretation just is judgment about intended meaning, that allows us to reframe the salient normative question that judges do face in a way that I think makes it pretty easy to answer. So the salient normative question for judges is not which method of interpretation should I adopt. There's only one method of interpretation properly so called. It's seeking the intended meaning of the text. Instead, the salient question, normative question for judges is, when they're confronted with a constitutional or statutory case, should I adjudicate this case according to rules derived by interpreting the relevant constitutional and statutory provisions, or should I adjudicate this case according to some other set of rules? And once we frame the question in that way, then I submit it's pretty easy to answer. There are very few people who are going to deny that judges in constitutional and statutory cases ought to adjudicate the cases according to rules derived by interpreting the relevant provisions. And I think there's a fairly straightforward explanation for why this is the case, and I go into it in the paper. Happy to say more about that during Q&A. But the upshot is that seeing clearly that interpretation just is judgment about intended meaning helps us to see that what judges ought to be doing in constitutional and statutory cases is applying the intended meaning of the relevant provisions. All right, this leads to the third implication. of the paper, which is that a version of originalism, both constitutional and statutory originalism, is correct. But it's a version of originalism that's heterodox in a few ways. And for the sake of time, I'm just going to mention one of those ways. But again, happy to say more about the others during the Q&A. It's a kind of intended meaning originalism, which is a kind of originalism that's very much out of fashion these days. The conventional wisdom is that public meaning originalism sort of put intended meaning originalism out of business in the late 80s and early 90s. I don't think that's right. I think that the old school, what Steve Smith calls the old-time originalists, basically had it right. They were right all along. There are a few of them still around, Larry Alexander and a few others, but I think they're basically right. The kind of original meaning that judges should be seeking is intended meaning. Now, I want to qualify that. As I explained in the paper, I do think that the appropriate notion of intended meaning is actually pretty close to what most public meaning originalists have in mind when they speak of original public meaning. So maybe the difference isn't that stark, but still, ultimately, the correct version of originalism is that old-time originalism, intended meaning originalism. And then finally, the fourth and final implication, there are no substantive canons of statutory construction. It's not just that substantive canons, if there were any, would be unlawful. There aren't any. I offer a few arguments for this claim in the paper. I'll very briefly just mention two. The first is that judges treat canons of statutory construction, including the allegedly substantive ones like constitutional avoidance, various clear statement rules. Judges treat them as principles of interpretation, and they apply them in the context of being engaged in statutory interpretation, almost in the same breath as they reaffirm that the goal of statutory interpretation is to identify Congress's intended meaning. Now, it would be really strange if immediately after reaffirming that the goal is to ascertain Congress's intended meaning, judges just turned around and invoked a principle that was openly aimed at something other than Congress's intended meaning, as substantive canons, as by definition substantive canons are. Second, if you look at what judges say about allegedly substantive canons of construction when they're defining them, they're explaining what constitutional avoidance is or the presumption against retroactivity is, overwhelmingly, there are a few exceptions, so I can't say universally, but overwhelmingly, judges describe these canons in linguistic terms. They describe them as presumptions about what kinds of rules Congress likely did or did not intend to communicate through its statutes. So there are no substantive canons of construction. They're all linguistic, and this matters. It matters because once you recognize that even canons such as constitutional avoidance that are traditionally classified as substantive really are linguistic, then if in fact they don't do a good job of tracking Congress's intended meaning, then they're open to criticism on that basis. And so that would provide the Supreme Court, at least, which is not bound by vertical precedent in the way that other courts are, that would provide the Supreme Court with reason to perhaps reform its use of some of these canons. And in the paper, I offer the major questions doctrine as one example of this. But with that, I see that I am a few seconds over time, so I'll stop.
Appreciate that. Professor Walsh.
Okay, one moment here. Let me get my timer set up. Okay, well, thank you all for being here, and thank you to Lee for the invitation to do this. The gratitude runs in both directions. I'm grateful for the chance to have read Charlie's paper and for the chance to comment on it, because it's the sort of thing comes across your inbox, say, I really need to read that paper. That is Charlie Capps writing on interpretation in something that's really important. I need to read that paper. But sometimes it takes a personal invitation to go ahead and engage. And so I don't know what the universe was telling me about my reading habits, but I got the message. You've already heard the main claims of the paper. I will just sort of report as a reader rather than someone who's just summarizing the content. It is a good read. This is model interdisciplinary work from someone trained in philosophy. I was a philosophy major, and sometimes in law, you're like, get to the point. What is your argument? What are your premises? Why does it matter? And to give you a sense, it sort of clearly lays it out. And then I just love the roadmap. It reminded me a little bit, it was slightly less aggressive than the conclusion of a paper by Caleb Nelson, which was just no conclusion at all, right? It just ended, I'm done. And Charlie's instead says, here's the roadmap. This article has 2 parts. Part 1 explains what interpretation just is. Part 2 explains why it matters. There you go, law review editors. So in terms of just the sort of explanation, now let me raise some questions about some of the main claims and why it matters. So the first claim, or why it matters, is there's no such thing as interpretive choice insofar as interpretation aims at the truth about intended meaning. Okay, what the author intended to communicate. Now, we have a lot of difficult problems when we come to applying that into federal statutes or the United States Constitution. And Charlie addresses these in the papers, but who is the author of a federal statute? Who is the author of a federal statute that's been amended multiple times? Who is the author of a federal statute that's been amended multiple times, where one of the rules of interpretation for figuring out the intended communicative content is to interpret it together with the rest of the corpus juris, or together to be consistent with common law rules, to take a substantive canon of construction, right? So one way to solve this that's addressed in the paper is to say, well, there's fictions, and we can interpret a work of fiction. And there, if you want to read the authors, the theorists who say there's no such thing as interpreting fiction, or there's no text or whatever, Charlie is aware of those, right? He's not avoiding those. He's taking them on. But in the legal context, I'd say the idea that Congress is a fictional author then raises a bunch of problems. Now, it's as if you're reading something that says this is written by so-and-so, but you know it was written by, but that's a literary device for the real author. But with Congress as a group, one position, and I think it's the position that Charlie adopts, is that it's a fictional entity. Now, there's another approach, and the approach that brought me around to legislative intent as the object of interpretation offered by Richard Eakins, is that there is a group intention that is real. That is, it's the intention to act or to enact into law the propositions that become true by the addition of the text to which the legislator gives a yes vote or a no vote. Something to that effect. In other words, it's a real intent, not a fictional intent. And so one sort of goad would be to address that difference more. Now, I happen to know from conversation before this that Charlie's already working on that. So to sort of preview that. Another would then be with constitutional interpretation. So Charlie's right that his approach yields a kind of intended meaning originalism. I happen to be one of those heterodox people that adheres to a version of intended meaning originalism, and I happen to come at it a different way that's tied to the realistic nature of the intention, and that is something like this. Who is the author of the Constitution of the United States? Now, and again, this is addressed in the paper, and so Charlie can address these different things, but it shows you the kind of challenge, because we'll back into the object of interpretation. But so, okay, well, what is the Constitution of the United States? Well, in part, it's a document. It's a promulgated law, so we're interpreting it as law. So we need an understanding of what law is, and the way I work into this is with the Aquinas' definition, or the classical definition, an ordinance of reason for the common good, made by one with a law authority and promulgated. And so who was it that had authority that promulgated this? Now, the Constitution says who the author is. We, the people of the United States. So a question is that a fictional author or a real author? And does it matter for figuring out the author's intended meaning for the Constitution? If it's a real author, what is the nature of this authorship, and how does it extend over time? Because if it's a set of people and people come in and out of the set, how does its identity change? And we have theories of explaining why, for example, a corporation is the same corporation over time, notwithstanding all its changes. And so when you make the claims that there's something that interpretation just is, you very quickly get into these kinds of things with law professors. So my suggestion, and I don't know if you'd adopt it or not, and it drives my colleagues crazy when I comment on their papers, is sometimes I can't get past the title. And so would it be a fair title or a better title for the paper to say there is something that legal interpretation just is? That is, that in fact, although your argument is devoted to there's something that interpretation just is, that it's essential for the points you want to make insofar as they're about legal interpretation, that you can't do without an explicit claim about what law is. You draw out these claims, you kind of gesture toward, not gesture, that doesn't say enough about how much you say, but the reason then that what might matter is because it forces us to think about what the object of legal interpretation is, and how much of that is actually about the interpretation of authoritative texts. So think back now, for all of you who are at this morning's panel, on a very discrete question about birthright citizenship. Now, there's a sense in which it's all about the meaning of subject to the jurisdiction thereof, but it turns out that the object of interpretation, when the idea is to say what did the framers and ratifiers of the 14th Amendment intend to communicate by adding that to the law, well, they intended it to be interpreted in light of all these other things. So if the object of interpretation is the entire corpus juris, then it seems there's not as much that comes just from the author of the text intending to communicate something.
Great. Professor Capps?
Great. Well, thank you so much, Kevin. That was great, very helpful. I'll just say a couple of things in response. I agree with you about the birthright citizenship example. I think it's a great example. And I think you're right that, and there's a lot of agreement, I think, among the panelists this morning, that the appropriate way to go about interpreting that provision is to, based on the premise that the intention behind the provision was to incorporate the common law rules, maybe modify them somewhat. Therefore, it matters a lot what the common law rules around birthright citizenship were. And yes, of course, that's going to be its own inquiry. But the reason why we embark on the inquiry in the first place is because we're trying to ascertain the intended meaning of the constitutional provision, and that is what sets us off on the road. So on the idea of maybe I should insert legal in front of interpretation in the title. Maybe. I mean, I think you're right that at the end of the day, what matters for purposes of the article is what legal interpretation is, not what interpretation generally is. The reason why I'm inclined to keep some discussion of interpretation generally in the paper is because it helps support my claim about what legal interpretation is. I think I can show that interpretation quite generally is about ascertaining intended meaning. If I'm right about that, then the two sides of the debate don't really come in on equal footing when we turn to legal interpretation. If in every other context interpretation just is judgment about intended meaning, well, presumably that's what legal interpretation is as well. But I take your point that at the end of the day, whether literary interpretation is an exception to my thesis or not really doesn't matter for the purposes of what I say later in the article. And then there's so much more to say about the problems raised by treating multi-member decision-making bodies such as Congress, I think this is true in non-legal settings as well, like a university committee, for example, treating them as fictional authors with fictional intentions. A lot more to say, but I won't try to say it now.
Great. We have a few minutes for questions from the audience or comments. And there's a microphone there.
Question for Charlie. So you mentioned what judges say in their court opinions about finding legislative intent. And I guess I wonder if that makes your argument more contingent than maybe you're giving it credit for. So for instance, is your argument sort of like a positivist argument that would say, well, yeah, as a matter of social fact, when judges talk about interpretation in our particular legal system, they say that they're doing this particular thing. Therefore, it is our law that interpretation is this particular thing. It seems that what judges say is sort of immaterial to your argument, that even if judges were saying a different thing about interpretation, that it's whatever Nero puts on the post up high, it would still in fact be what interpretation just is. So I guess where does like the social fact of judges making determinations fall into your equation?
Yeah, it's a good question. I think I want to leave open the possibility that there's a specialized meaning to the term legal interpretation that's just, it'd be kind of strange if this were true, which is, again, why I discuss interpretation generally. But, it's like we can imagine that this is like a term of art. It just has some stipulated definition that's different from judgment about intent and meaning, which is what interpretation means in all other contexts. And the way we know if that were true is we look at the folks who participate in the practice in which this term of art is used. And we'd ask, well, how do they use the term? That's going to tell us what it means. And so if judges and the legal profession more generally use the term in some specialized term of art kind of way, then I say, okay, what they mean by legal interpretation is something else. That's why I focus on what judges say. Because at the end of the day, I think we should all be positivists in a sense. About the meaning of words, ultimately, the meanings that words have. It's just a matter of use, and so it's a social fact, and so that's why I look to the participants in the relevant practice to try to determine what legal interpretation is.
To Greg, your paper seems to be essentially defending the myth of progress and then making the claim that the common law is the best means of dealing with it. I guess on the first point, in case there are any conservatives in the room, I would say that it's possible that maybe the myth of progress is not correct. As I was listening to your examples, thinking of a few things, and here I'm echoing or reframing things that Professor McLeod's already said, but Neil Postman's amusing ourselves to death, Richard Weaver's ideas have consequences, and more recently, and especially related to AI, Paul Kingsnorth's Against the Machine are all things I think worth considering. And these all go to a key part of this, and certainly Burkean conservatism is not against progress, but the issue of speed is important. And I think the point is that the common law takes time. Do we have enough time, especially with a technology like AI, that's claiming it's going to change the world in 5 to 10 years? What if it does? Right, so as an analogy, another technology that changed the world very quickly, automobiles, do you think the common law would have been an appropriate way to deal with automobiles, or was it better to statutorily decide we're going to drive on the right and we're going to have speed limits? That's the question to you. Thanks.
Yeah, so a couple things I can say in response. I don't think that you would need to adopt an idea that history is always winning, always succeeding in every change that occurs, to worry that legislative intervention in particular is likely to go wrong. And so I would say probably in general society does improve, but even in those moments where some sort of adjustment is necessary, you might reasonably think that the courts, rather than the legislature, is the best way to accomplish that. And so that's, I guess, my initial thought on the first point. On the second point about automobiles, I have to say, it's hard to say exactly what the world would look like if tort law had gotten to govern everything about automobiles. But the idea of driving on the one particular side of the road or something like that, that is, when people ask me, when would you like a statute? Well, that's the kind of statute I'd like. When some sort of decision needs to be made, where there needs to be some sort of collective organizing principle across society, and it's especially when it's somewhat arbitrary, there at least I think we do need statutes. And so you got me on that point. I have to concede the side of the road statute.
I think we have time for one more brief. Yes.
This is a question for Professor Capps. I was just wondering about the substantive canon, especially constitutional avoidance, the sort of broader version of that, the avoid even serious constitutional questions. I wonder if you could give me an example, a specific example. Like, for example, we do not interpret the word agency in the APA, even though it has a very capacious definition to include the executive office of the president. And that's always, I think if you ask members of Congress, they'd be like, oh, yeah, definitely, we want to cover that. Like, terrific, awesome. And yet, the courts go the other way. So, I think I think I've always struggled with this as to whether it's substantive or not. I wanted your thoughts on something specific like that, where I think if you really follow congressional intent, I think it may be very hard to say that Congress wouldn't intend that. Now, maybe you could just say it's wrong. So I wondered, give me a concrete example of that, or you could take Catholic bishops or something else like that and say, oh, Congress, I just want to hear, what your position is on at least one concrete case, and maybe the APA would be the best.
Sure. So I don't have a good example off the top of my head about constitutional avoidance, but we can use the example you offered of agency. The APA so much better than I do, so I'll just take your word for it, that it's the narrow interpretation that the court reached by applying constitutional avoidance it's not plausible that it reflects the intended meaning of the statute. To the extent that's the case, you called it, what I'm going to say. That's the wrong decision. The court got it wrong, and constitutional avoidance should be pared back. The justification that courts offer for constitutional avoidance when they're describing it is, well, we presume that, look, they say this quite explicitly. They say, look, these are government officials who've taken an oath to uphold the Constitution. Like, we can expect that they'll probably, do their best and try to do that. So if there's a proposed interpretation of a statute on which it's obviously unconstitutional, we think, those upstanding members of Congress who really take their oath seriously, that couldn't be what they meant. Now, you might think that's bogus, but that is the explanation for the canon that courts offer. I think we should hold them to that and say, to the extent that that explanation can actually carry weight in the particular case, and go ahead and apply the canon. But if not, then don't apply it. For another example, the major questions doctrine, this is the one I discussed in the paper. You look at the colloquy between Justice Barrett and Justice Kagan in the student loans case. And Justice Barrett is saying, look, I think we should think of the major questions doctrine as a linguistic canon. If there's a huge important question, then probably Congress didn't intend to delegate it to the agency unless Congress is explicit about it. And I think that's right. But then, ironically, it gives bite to Justice Kagan's argument in dissent. She says, well, actually, there's good reason to think that Congress deliberately kicks all kinds of important questions to the agency. Maybe it's it's too politically sensitive, Congress doesn't want to touch it, or maybe they can't cobble together the majority they need to pass the legislation if they actually try to resolve it, so they just boot it over to the agency. There's reason to think Congress does this on purpose all the time. Well, I think Justice Kagan has a point. I don't know if she's right about how the student loans case should have turned out, but once you conceive of the major questions doctrine, as I think we should, and as Justice Barrett does, as a linguistic canon, then it ought to operate as only a kind of weak, context-sensitive presumption, and maybe can't support all of the court's uses of it in prior cases.
Thanks so much to our panelists. We're going to take a very short break to change it out.